Good morning. The day-to-day burning problem as a lawyer as well as being a social member running family care about their forefathers' property. The question of execution of will, probation and letter of administration is playing vital role between the blood relations. So this judgment deals with such a case. Multi-number of time it was held that under section 137 Limitation Act prescribes 3 years from the date of death of the testator. The will should be probated. But later on they say since it is continuing right, so limitation may not be considered as a bar to probate the will unless the other side proved that the will was not executed and this is suspicious will. But here the judgment which I am going to discuss with you, you should go through the judgment and understand that how the respondent counsel or respondent did not conduct the case properly, resulting will is being permitted to be probated. So the thing is that this is judgment of AR 2025, AR 2025, Jharkhand 104, AR 2025, Jharkhand 104, Bansidhar Sahu versus Shivakumar Gupta. Bansidhar Sahu, Shivakumar Gupta. This case they say number one, the will was registered some 30 years before, and the explanation of the person who sought for letter of administration was that it was found when they were clearing almirahs and bookshelves. So the lower court dismissed the letter of probation and High Court allowed it on the ground. There were several grounds where they say under Evidence Act section 90, which deals with how the document on record and custody of more than 30 years to be proved. Section 90 of the Indian Evidence Act read with section 80. All that been discussed. Then they say once other side accepted the registration of will, so then they challenge about the execution was not proper or not by the person who bequeathed the property. But unfortunately, since the date of will was 30 years back, the attesting witness could not be examined. So the High Court, Jharkhand, set aside the order of dismissal and allowed remanded back for should directed probate be granted. He granted the probate. Formal letter of probate as per Schedule 6 of the Indian Act shall be issued by the court below. Deficiency, if any court fee, shall be made up. This is what they have said it. So section 90 deals with, they say, the High Court says twin presumption. Twin presumption was there. Therefore, after also holding that the right to apply to probate is continuing right. So all these things you go through, and why there was no cross-examination about the availability of attesting witness or about genuineness of the attesting witness and the particular and identification. All these lapses on the part of there. So by going through the judgment, you will be very careful in defending the letter of administration. I hope you understand. Best wishes.